turned it off while we were just sort of sitting here staring at each other. All right, now we're back to that. So the question before the House is, do we care what sort of relationship there is between property and freedom? Do we care? Yes.
From the simple lawyer client or lawyer as your career choice, I don't think we can. And to that extent.
Okay, why not?
Because whether it is in fact linked to freedom or not, it doesn't change the purpose of the career goal. That makes sense. Your client wants this, they ask you for this, you will do it to this specific point. So it wouldn't be practically of the sense that you would contemplate that while handling that case. That makes sense.
Okay. Chris, you started to raise your hand.
Yeah, kind of along the lines of what Chad said. I don't think consciously it really matters, because that's not what we're here to talk about. We're here to talk about whatever it is you came to me about your property before. We didn't come to talk about whether or not it gives you freedom.
Well, think about this though, right? Because I think you're both sort of attaching the right argument, right? Is that if what you're really interested in is moving forward and sort of knowing what you need to know to progress in a legal career, then these larger sorts of questions are not all that important. But what do you do when, let's say that the legislature passes a law and says that laws limiting the ability of non-nationals to purchase land are not uncommon in the Caribbean, right? There are, St. Vincent has some rules restricting purchase of land by foreigners. Trinidad and Tobago does it as well, I believe. Barbados does not. And so maybe a law sort of restricting future purchases isn't terribly controversial. But what if the legislature passes a law and says, the House of Assembly here in Barbados passes a law that says that all non-Bajans who own real property in Barbados have 10 days to divest themselves of their property, or it will be seized by the state. How do you respond to that as lawyers? What do you do? Yeah.
You mean as a private lawyer or like a government lawyer or what?
I mean, I'm asking just broadly as members of the legal profession, what's the response to this? Now let's back up the hypo a little bit, rather than it being a law that has been passed and proclaimed and has gone into effect, and now we're trying to deal with what do we do? Let's ask a question that's a little earlier in the timeline. Government announces their intention to pass such a law. What do we as members of the legal profession do?
Hello.
File an injunction. Sure, okay, great. The court goes, government has the power to do this. Maybe they do, maybe they don't. I'm not an expert in Barbados constitutional law. But let's say that the court says, no, injunction denied, government has the power to do this. What do we do? I mean, there are certainly people out there who will tell you that in this circumstance, the right thing to do is to do what the law says, is to go along to get along, don't make waves, live your life and try not to make a ruckus. That's a reasonable thing to do. Yeah. You know what people who did the reasonable thing did in, say, Missouri in the 1840s? They handed over runaway slaves. You know what people who did the reasonable thing in Germany in 1938 did? Turned over their Jewish neighbors. So this is why, to my mind, I think it matters whether property is part of how we conceive of freedom. Because the deprivation of property, that deprivation of freedom, if you think it matters, that's a step. And it's one that we, as lawyers, should be prepared to know whether we think it's appropriate or not. So, if you ask me, do I think this question matters? I think it does. Do I think that I have the only right answer? No. I think that there is room for people to disagree. But I think that you can disagree about the answer while still acknowledging that the question matters. And in that sense, right, in that sense of acknowledging the importance of the question while still being engaged in dialogue about what the right answer is, the rest of the readings that are assigned for this unit on fixtures basically encompass a series of arguments that contradict everything that Professor McIntosh had to say that we talked about on Tuesday, right? So these are readings that focus on the collective good aspects of property law, right? The ways in which we can use property to serve the interests of the entire community, and not just the interests of those few people who are fortunate enough to own said property. Okay? So the first question is sort of raised by Professor Rolston's article from the Whittier Law Review, which is, does the fixtures doctrine prevent economic waste? Okay? And one thing, you know, that may sort of be a little beyond the scope of the class is like, what is economic waste? Okay, economic waste, the economists tell us that it's just the inefficient use of resources. Okay, so the reason why Professor Rolston says the fixtures doctrine starts to develop is it grows out of this accession doctrine from Roman law. Okay, accession being a concept that we see in the common law related to personal property, where things that are combined that can't be separated become treated as one item, right? So the example that Professor Rolston gives is the thief who steals paint from one person, steals a canvas from a second person, and then creates a masterpiece of artwork using stolen paints and stolen canvas. Who owns the painting? Who owns the painting?
Sir, could you just backtrack on this because I didn't get the link between the analogy that you just gave and what you're saying.
Okay, so the idea is that we're interested in economic waste, right? And the issue is we're connecting items in a way to make them one thing. Okay? Does this sound familiar? This is the fixtures doctrine, right? We're taking two things that are separate and we are now declaring them to now be one thing, right? We've got land and chattel, and now through the magic of the fixtures doctrine, we have just land with a fixture, right? Same thing, taking two things and creating one thing out of it. Okay, so again, right? Stolen paint, stolen canvas, thief creates a masterpiece. who owns the painting?
I say,
Why?
because,
The answer, by the way, for those not in the room, right, Carrie in chat says the same thing, the thief. So why?
because it's, okay, the new object is his. So you ask who owned the painting, and he created this new object, therefore it belongs to him. You didn't ask like who owns the paint in the painting, you ask who owns the final product, and seeing as he is the maker of the final product, I would say it belongs to him. Whether illegally or legally, that's another question.
Okay, so does the owner of the paint have the right to scrape it off the canvas and take their paint with them? No?
I would say so.
But it's stolen paint, it's his paint, or her paint, or their paint. So he still, the owner of the paint still has a lawful property interest in the paint. Why can't he scrape it off the canvas? Why can't the owner of the canvas pick up the canvas and walk off with it? And, oh, he happens to carry away this paint, but it's his canvas.
But the paint didn't even exist without the canvas and the painting.
I'm sorry?
But the paint didn't even exist without the canvas or the painting.
No,
So technically, yeah.
no. There is no art without the materials in this hypothetical, right? So the question Monique asked, for those of you not in the room, is, does the canvas painting exist without the paint and the canvas? The answer is no. The answer is no. Okay, so Carrie in the chat says that the materials used to create the painting are not his, but it's his creativity and his ideas, right? So you're all sort of getting more or less the right answer, okay? The sort of full explanation of the reasoning has to do with distinctions between legal ownership and equitable ownership that we haven't gotten to in this class yet. But basically, it's very likely that the thief owns the painting, but if and when he ever sells it, the owners of the stolen goods can seize some of the proceeds to gain restitution. That's the outcome in the types of cases that are like this, right? So, Megan asked about shares, not quite, right? So it's not quite like shares in a company or shares in a piece of land. And we're going to talk more about sort of fractional ownership a little bit later today. It's because it may very well be that the thief is not entitled to any of the proceeds, right? It may be that all of the proceeds are snatched up by the equitable beneficiaries, being the owners of the stolen goods, right? That's a fact-driven question that is going to depend on sort of specific details that aren't in the hypo, because that's not what we're concerned about, okay? Another reason for developing the fixtures doctrine, according to Professor Ralston, right? You guys may not know this. If you don't, I'll tell you, don't worry. But do you know the difference between secured and unsecured creditors? It's okay. It's okay. The only difference is a secured creditor has something that the debtor owns that they can seize. Okay, that's all that means, is that there's something that the debtor has pledged as security. Hence the term, secured creditors. Here's the problem. If unsecured creditors aren't getting paid, how do we keep them from going into, say, the factory or the business of whatever type, and just grabbing the machinery that would satisfy their debts? How do we prevent that? Give you a hint, it's what we're talking about. Yes, Nicole, go ahead.
Sorry, that was an accident. But
I'm sorry, you're not, give me 1 second to see if I can turn you up, because you're not coming through. Give it another go, Nicole.
no, sorry. Can you hear me? I was saying that was an accident, but I'm just wondering if it's because it's not because it's their personal property.
That wouldn't stop them. So,
Okay.
but what might stop the unsecured creditors from, aside from a bankruptcy, that's a whole different issue. What might stop the unsecured creditors from going in and taking apart the machinery in the factory and just being like, okay, well, I'm owed $10,000 that I haven't been paid. It's 6 months past due. You know, I'll take all of the screws in your machinery and I'll sell them, and that'll make my $10,000.
I'm assuming you just have to put a security on it. Does that make sense?
What do you mean by put a security on it?
Well, to prevent someone from actually going to your factory, there would be legislation to say you can't come and steal my things because you are old.
Well, you're so close. You're so close. What if, could your unsecured creditors come in and just take the land that your factory sits on? Right? And they scoop it up and take it away from you? No. Right? So what if the machinery in the factory is part of the land? Right. So this is the argument for the industrial motivation behind the fixtures doctrine. Okay? So the argument is that the goal is to prevent the creditors from taking apart the machinery in a going business. One of the things that Professor Rolston points out is that if we go back to this Ohio case that he talks about, the Teeth case, that is the first statement of the intention test for the fixtures doctrine. First statement, right? This is the, by the way, this case, this Ohio case, is cited sort of everywhere that the intention test is used. Okay, Justice Wooding cites it in Mitchell versus Cowie. You know, this is where this test comes from. Does the court in that case even actually rely on the intent that they claim is so important? And Rolston says no. And he marshals sort of quite a bit of evidence to suggest that really, the test is a smokescreen. That, the intent of the affixor is whatever the judge decides it's going to be. That there's not, he argues that there's not really law here. There's only power. Okay? One thing to keep in mind is that he does in fact point us to cases, right? One of the things that we talked about when we were sort of describing the shape of doctrine, right? One of the things that we talked about is that if the structure is held on the land by more than its own weight, it is presumptively a fixture, right? We talked about that, and vice versa. If it's only held on the land by its own weight, it's presumptively not a fixture. And Ralston finds us cases where both of those statements are not true, right? So we have cases where structures are actually attached to the land, and it's no, these are still chattel, right? We can even see that in the Caribbean with the case of the army barracks, right? That was intended to be quickly dismantled and removed from the land. And then we have cases where it's just a structure that is held down by its own weight, and in fact, it's held to be a fixture. So Ralston's argument is that this intention test that we sort of cling to and we waive in these cases is really just a mask for something more mystical, okay, something that he describes as being sort of a ceremony of affixation, okay, and that is based on the transaction, okay, the transaction. So let me ask you this. Can there be a transaction with only one party? Can there be a transaction with only one party?
Traditionally, no.
I would agree with that. The answer is traditionally no. I would agree with that. I would even go so far as to remove the word traditionally. I don't know of any transaction that has one party. And I'm not the God of all, do not know everything, but I don't know of any such thing. But with fixtures, we have a one-party transaction. Because only one party determines whether, according to how the doctrine is stated, determines whether the chattel becomes a fixture. Okay? And this is sort of the difficulty, and a couple of folks have asked questions related to this, right? The owner of the land brings something onto their land and affixes it to the land and intends to keep it there, and it's now a fixture. And then 5 years later, the owner goes, I don't like this thing anymore, I want it gone. And they go out there with their wrenches and their screwdrivers and they remove the thing and they take it off the land. And now it's no longer a fixture and it's a chattel again. And nobody participated in this except the owner. And Ralston's argument is that this doesn't make any sense. We don't talk about anything else in the law this way. So why do we still talk about fixtures this way? I don't have a great answer. I'm open to suggestions. So the good news is that this is not news. These difficulties, these complications related to the fixtures doctrine, this is not something that is sort of going to shock people in the year of creation 5781, okay? These are things that governments have been thinking about for some time. And in fact, here in Barbados, there have been some things done to try and resolve some of this, right? So one issue, right? What happens to the sewage generated by a chattel house resident? If I lived in a chattel house and it was a true chattel house and it was not affixed to the land so that I could move it upon the end of my tenancy, where would I go to the bathroom?
But most chateau houses have like a runoff, so like, especially nowadays, they're usually close to like a gully. I don't know if that's what they call it here in Barbados, but we don't even call it a gully. Or unfortunately, sometimes you have rivers near the sea, but the point is usually persons build their houses in a way that there is an automatic runoff that uses less work so that they don't have to manually empty their rooms.
Okay, I mean, that seems perfectly reasonable to me. What does that do to, say, the environment? By the way, for those not in the room, the answer was that most chattel houses are built in such a way to create like a natural runoff so that wastewater and other waste just sort of flows away from the house into a gully or into the sea or wherever. So what do we think, and what do we think might be the environmental effects of that?
Pollution.
Yeah, Megan says the owners of chattel houses have definitely contributed to water pollution. Sure, right? Yeah.
So in Trinidad, right? A lot of people have something called latrines, which is like a structure outside your house and have a toilet, and it's attached to a suspect. So to move in a chattel house, you move your latrine also to a suspect.
These are all perfectly reasonable solutions, right? For the owners of the chattel houses. Okay? Be they runoff setups, be they pit latrines, right? All of these are ways that people have solved this problem. But governments can look at the broader picture. And so that's sort of what happened here in Barbados, okay? With the Tenantries Freehold Purchase Act of 1980. And the details of how that works don't matter, but basically a tenant who occupied for a long enough period of time had the option to purchase the land that their chattel house sat on in fee at a fair market value over the objections of the landlord. So this is, by the way, in case you were wondering, if you read the Potter article, which is the Urban Housing in Barbados article, you will note that in 1980, when this statute was passed, 52% of Barbados households used pit latrines. I don't have the number for how many do now, but I would lay very good odds it's a lot less than 52%. And part of the reason for that is one of the legal developments that kept people using pit latrines and runoff systems for waste management was out of a concern that if they connected their house to a water-based sewer system, that the house would become a fixture and they would lose it. The audio quality is not, we'll see if this goes any better. Let me know if you can't hear me at all. Yeah. So, okay. So, do we see how these doctrines have effects sort of beyond the private effects that we see, right? So Professor McIntosh talks about how in order for property to be properly conceived, you have to divorce it from common good concerns. You can only treat property as a private good, okay? But I think that this example, right, of how being concerned about common good issues and recognizing the role that common law doctrine has played in creating these externalities, I think that's a really important understanding of the role that property plays in broader concerns, right? If we were only interested in the private law conception of property, then there would never be any mechanism for a tenant to convert their interest to ownership except by the consent of the landlord. And so there would never be any reason for a tenant to attach their chattel house to the sewer system, right? So this is why we want to think more broadly. This is why we want to be open to having these kinds of conversations. Let me ask a different question. And this question is sort of transitioning from fixtures to what we're going to start talking about in next week's lecture, which is the doctrine of estates. So if you read the article by Jane Matthews Glenn, you would have learned, and some of you probably already know about it in broad strokes or even in detail, about the notion of family land in St. Lucia. Okay? What is family land? I'm sorry?
We're waiting on Travis to speak because he's saying.
You can pass if you want.
I may be wrong, but from what I've seen around in St. Lucia, family land is where a wealthy enough family owns multiple streams of like estates and property. So for example, Beaufort, one farm, that's a place in St. Lucia. Sure. One family will own X amount of land in St. Lucia, enough to qualify like half of the industry thereabouts. So family land is just that. A large percentage of the land are not necessarily one person owns, but family owns and has a right to use.
Yeah, that's exactly right. Okay, the family land concept in St. Lucia is a collective ownership doctrine. Okay, it's a process whereby a parcel of land, and it can be small, it can be large, be whatever, it's owned by a collective, and usually these collectives represent some sort of familial structure. Okay, and they can actually be quite extended because it can be a situation where in order to have the resources to acquire enough land to support the family, you actually have to bring in lots and lots of family members. And so it can become quite extensive, right? With lots of aunts and uncles and cousins sort of all wrapped up in the parcel, okay? Family land is held in common by all of its owners. So they all have equal rights to partake of it. And we'll talk about what that means in more detail when we talk about estates over the next couple of weeks. And one of the things that they have the right to do is to transfer or alienate their shares. So what do you think so let's say that we start with a parcel that is bought by 5 people. Okay, they manage to, 5 of them have enough resources to get it together and buy this parcel of land that will support the 5 of them. Okay, and they all own it. They all have equal shares. If we fast forward the clock 50 years, what do you think has happened in a very generic sense, right? I'm not asking you to sort of tell me, because I have not given you a lot of detail, but just in a very generic sense, what do you think has happened over the course of these 50 years? Do you think there's still 5 owners of the land? Travis, you're shaking your head. Do you think there's more than 5 or less than 5?
It depends, because by 50 years' time, the land is split up into the children.
Yeah.
And then passes on and then to produces. Sometimes some of those children will sell all parts of the land to some other owner, and sometimes they'll keep them pass to their children.
Yep.
So on and so forth.
This is absolutely correct. This is completely correct in all its particulars. But because you can't sell more than you own, right? So child A owns 1/5 of the land. They have 3 kids who now each own 5 times 3, 1/15 of the land. So one of those kids has 4 kids of their own who each own how much? 1/60th of the land, and so on, and so on, and so on, and so on. This actually happened in the United States with Native American lands, and at one point, there were people who owned less than 1/1000th of a given parcel of land, and the parcel itself was barely large enough to support one family. And people, and this was the size of the share that people had. And while I don't know the details of what happens on St. Lucia, that, given how the doctrine is structured, that type of thing is a possibility. So, Travis, do you know whether that's something that's happened?
No, because when land is not going to be passed down to children, if it's not big enough to at least do something with it, it will not make sense to split it up. So if you have enough land to host three-story marshals, you could split it up. But if you have enough to go one, you will not just give it to whoever you give it to.
Your favorite child. Not that any parent ever has favorite children, right?
Yeah.
Well, that sounds like St. Lucians are more sensible than Americans. So, but I think that Rayon says facts, fair enough. So I think that the important lesson to take from this, right, the thing that I want to sort of communicate to you with this, is that the formal law doesn't always reflect how actual practice operates, right? We will be learning the formal doctrine. We will be continuing to learn the formal doctrine, but we will also at times be talking about how things operate, sort of without regard to the doctrine. And some of the questions that we'll be asking is, how can we shape doctrine to reflect actual practice? Okay. So, tutorials pick back up next week. I am continuing to work on clearing the marking backlog. Next week's tutorial does not have a submission associated with it, so you will not be submitting work with the next week's tutorial. It will be a discussion in breakout groups that I will be creating, I really hope, tomorrow. Really hope I'm going to get to that tomorrow. Did not hope to get more done last night than I did, but as I said in my email this morning, I had an unexpected illness and had to take care of that. So with that, I'm going to let you guys go a couple of minutes early today, and we'll see you guys. Those of you who have tutorials on Monday, I'll see you on Monday, and the rest of you, I'll see you on Tuesday. So thanks a lot, and if you need anything, don't hesitate to reach out. And I am going to end the session.